Hello, everyone, and welcome to Uncivil Law. For today's case, we have a situation with a person who was wrongfully convicted and is seeking some redress for violations that caused him to be convicted. This is the case of Cornell McKay versus City of St. Louis. So we're going to read what happened in this case and what kind of remedies he's seeking and whether or not he can get them. So let's get started with this. On August the 10th, 2012, a Jane Doe was leaving her car outside her condominium in St. Louis when a man walked right up to her at arm distance, pointed a gun at her, and demanded money. The man took $50 and her cell phone. Doe reported the robbery to the St. Louis Metropolitan Police Department that same night. She described the suspect to the police as a young black male with a light complexion, 16 to 20 years of age, 6 feet and 3 inches tall, and weighing 150 pounds. On August the 18th, 2012, a man shot and killed Megan Boken during an attempted armed robbery less than 3 blocks from Doe's condominium. A day later, homicide detectives assigned to the case were alerted to the similar location of these two incidents. So they're saying, well, maybe there's a tie between them. So maybe there's a tie between this person who is jacked on the street and this murder because they're in the same location, similar time frame. The homicide detectives then met with Officer Stamper and asked for information about the robbery. Officer Boingemer generated a photographic lineup using images of McKay and 5 others with similar characteristics as McKay. He showed this lineup to Doe, who identified McKay as the man who robbed her. So we think McKay might be our guy. We generate a photo lineup. We put McKay in the photo lineup along with other people who are similarly situated. Now, assuming they're similarly situated enough, this is how you're supposed to do a photo ID, right? You put them in an array with people who look very similar and say, which one is it? And if you get the right one, that's enough to at least give you some information to go forward. He then showed this lineup to Doe, who identified McKay as the man who robbed her. As a result, the officer issued a wanted notice for McKay, who surrendered himself. The officer then organized a physical lineup consisting of McKay and 3 others with physical characteristics. Okay. The fact there's only 3 others is probably too few. I'm not an expert on this field, but I'm pretty sure 6 is the magic number. So you only have 3 others rather than 6 total. I think that's too few. I think your lineup is going to be a problem. Doe again identified him as the robber. So we identified him based on a photo lineup. Now we're identifying him in a physical lineup. But we don't have enough people the second time. That's a bit of an issue. And it's also a bit of an issue that McKay is the only one who presumably appears in both sets, and it's the same witness twice. That's a problem. So yeah, it's the same. It's only one person who's common to both sets. So that's not so great. A grand jury subsequently charged McKay with 1 count of first-degree armed robbery and 1 count of armed criminal action. Meanwhile, detectives from the homicide unit had begun running a separate computer search based on Doe's cell phone spreadsheet. These searches led them to Caitlin Perry, whose number had been called in the days after Doe's robbery. When the officers interviewed Perry, however, she told them only that Esther's had given Doe's cell phone to use sometimes during that week, and after that, the cell phone had stopped working. The officers tracked down the person who had purchased the phone at the gas station, and that person confirmed he bought the phone. In February 2013, Doe was shown a phonograph lineup that included Esther's, but did not identify him as the robber. Esther's later confessed to the murder, but repeatedly denied involvement in the robbery. So we have a separate investigation that's still ongoing. We have this guy, Esther's, and we have someone who's identifying them as the murderer, but not the robber. Okay, so that's that. In December 2013, during McKay's trial, Doe again identified McKay as the man who robbed her. A jury convicted McKay of both the armed robbery and the armed criminal action. So we have a jury who's trying this guy for both the murder and the armed robbery, and we're going to convict him of both. And we have some evidence that goes the other way because we have some witnesses who said some other things. Now, if the jury's told all this, that would be fine because the jury can reconcile. What evidence is reliable and what's not, and they can as long as there's sufficient evidence, they can choose which evidence to believe. But if you don't tell the jury, that's going to be an issue. The court sentenced him to 12 years for this violation. The Missouri Court of Appeals reversed the conviction on the grounds the trial court erred by granting the prosecution's motions to exclude any reference to Esther's and remanded the case for a new trial. So yeah, we kept out information about this other potential person. So the prosecution moved to suppress information regarding this other suspect, which was granted. So the jury never heard about this other person who was identified by other witnesses who might be involved. So that's a problem, right? The jury never heard about it. Okay. Because Doe did not want to testify at another trial, the state declined to hear and McKay was released. Because you screwed it up the first time, way to go. McKay filed suit against the police defendants, Spence, his former probation officer, the board defendants, and the city, among others. He asserts claims under 1983 against the police for violating his constitutional rights by suppressing or destroying evidence against the police, and Spence for violating his constitutional rights by fabricating evidence, failing to investigate, and conspiring to deprive him of constitutional rights, and against the board defendants and the city for imposing certain policies, customs, or practices in violations of rights. So he's going on the offensive. He was convicted of these things, these armed robbery times two, and it was never mentioned at his trial, this other person who was identified who might be valuable. And the Court of Appeals says, no, you can't do that. You had to tell the jury about it. So they vacate the conviction. The state says, we want to do it again. The witness says, no, I don't want to. And so the state says no. So now he's going on the offensive and says, oh, you improperly imprisoned me. So I'm going to sue you for violation of my constitutional rights. All right, can we do that? Let's find out. McKay first argues that the police defendants violated his due process rights by suppressing or destroying evidence. Suppression of material exculpatory is a violation of due process under Brady, which is your go-to case for this. To demonstrate a Brady violation, a plaintiff must show the prosecution suppressed the evidence, it was favorable to the defendants, and the evidence was material. McKay asserts the police defendants failed to preserve Doe's phone in such a way that evidence could be gathered from it, suppressed the true nature of Perry's statements by making it appear the police defendants did not know that Perry's had implicated Esther's in Doe's robbery, and lost or destroyed an alleged video of an interview that they had with Perry. So he's saying, well, there's some evidence here that you either didn't keep properly or destroyed. You had a video interview with this other witness. That might be material. You had information on the cell phone. You destroyed that information. That might be material. So there's some information here that you didn't give to me during my trial. The district court correctly granted summary judgment to the police on the Brady campaign. So the district court says, no, you didn't have a Brady violation. Okay, why not? Let's read on. McKay concedes there's no evidence on the phone that was intentionally destroyed, let alone destroyed in bad faith or on behalf of the police defendants. Bad faith can be shown by proof of officials' animus or a conscious effort to destroy evidence. McKay states only the phone is now destroyed, and no one can provide an explanation of how or when the phone was destroyed. So the evidence is now gone, but we don't know why, and we don't have enough information to implicate the police. So there, you can't prove they did anything, or they intentionally did something, or even negligently did something. We just know the information is now gone. We don't know by whom. Okay. Second, McKay asserts the police defendants failed to disclose that Perry had made statements implicating Esther in the robbery. Although it's unclear from McKay's brief which specific statements he alleged were suppressed, McKay proffers no evidence that police defendants were ever told about the statement by the homicide detectives that she believed Esther committed the Doe robbery. So this is a little bit of one hand washing the other problem, but it is not unexpected that different departments or different police officers wouldn't necessarily share information. So you can't force disclosure of things that weren't known. So the robbery detectives didn't have information from the homicide detectives. Now, actually, I believe that. I believe that's totally possible, because information is typically held fairly close to the vest for a whole bunch of prudential reasons, and people are just territorial in general. So I believe it's completely possible, and more likely than not, the robbery detectives had no idea about this exculpatory evidence. Now, that is a problem, but it is believable. Thus, the record does not support that these police detectives suppress statements, let alone suppress them in bad faith. You know, one might query whether or not police should be implicated by everything the police know, but that is a fair statement of the law as it exists right now. Third, McKay asserts a video of an interview of Perry by officers conducted in the homicide unit was either suppressed or destroyed. Although officer testified his understanding that every interview is automatically recorded, McKay proffers no evidence that this particular interview existed, let alone that it was destroyed or suppressed in bad faith. McKay next argues the district court erred in granting summary judgment to the police defendants on his claim that they fabricated evidence in violation of due process. Specifically, he asserts the police defendants improperly persuaded Doe to choose McKay's image in a photographic lineup and exclude statements made by Perry to the homicide detectives. A lineup that deprives the accused of a fair trial offends due process and can be actionable under 1983. To determine whether an identification procedure violated due process, we consider whether the identification was impermissibly suggestive and whether, under the totality of the circumstances, the suggested procedures created a very substantial likelihood of irreparable misidentification. McKay also argues the police defendants violated his constitutional rights by recklessly or intentionally failing to investigate Esters as a suspect in the robbery. We have recognized that constitutional violation occurs when the officers fail to investigate, was intentional or reckless, thereby shocking the conscience, which is a pretty high standard. McKay's assertion that the police defendants failed to even consider Esters as a suspect in the robbery is contradicted by the record. After learning of Esters, the officers interviewed Perry about Esther's connection to the phone, and then include the photograph in a lineup for Doe to identify. During this lineup, Doe pointed out physical differences between Esther and the attacker, like Esther's too thick eyebrows and too dark skin tone. Moreover, Doe constantly identified McKay as the robber, and Esther's admitted to the Boken murder, but repeatedly denied any involvement with the robbery. Considering this evidence, we agree with the district court that police defendants did not fail to investigate, let alone do so in a reckless or intentional manner, so as to shock the conscience. McKay next argues that police defendants engaged in a conspiracy to deprive him of constitutional rights. To prove a conspiracy claim, McKay must prove the defendants conspired with others to deprive him of those rights. At least one of the co-conspirators engaged in overt act in furtherance of the conspiracy, and the overt act injured him. For the reasons stated above, we agree with the district court that the police defendants are entitled to summary judgment on the conspiracy claim because they failed to provide a genuine dispute of material fact concerning the deprivation of the constitutional right. So that is the end of the case of Cornell McKay versus City of St. Louis. In this case, we learned that Mr. McKay was convicted, perhaps wrongfully. There was some information that was withheld from the jury improperly at trial. As a result, it was set aside. And the person didn't want to testify again, so there was no retrial. And now he's going on the offensive and suing. But the Court of Appeals says no, the police didn't violate your rights under Brady. They didn't violate your rights because they gave you everything they had as part of their stuff. This stuff was unknown to them because police officers are proprietary, different divisions, and all the rest. So they didn't know about it. They gave you everything to know. There's nothing wrong with these lineups that they did. And, there's no violation here. And also, probably you did it. We're not going to say that part out loud, but yeah, you probably did it. You were the person it was done. But, so you can't go on the offensive and sue for violation of rights. You got everything that you were entitled to. The conviction was wrong because the jury wasn't allowed to hear mitigating evidence. So that was wrong. That's been set aside, but there's no additional relief to be had here. So that is the end of the coverage of this case.